Good afternoon.
Hi.
Professor Bell, Avi Bell. I'm here with Avi Bell. Welcome to Cup of Joe. You are a professor, I understand, at Ilan University and also at the University of San Diego.
That's right.
You have a law degree from University of Chicago.
And another one from Harvard.
And from Harvard. I understand that you teach property law and international law. Is that correct?
And intellectual property and a couple of other things. But okay. Yeah, those are the main things are property and international law.
Mm-hmm. Okay, the main focus of this podcast, this episode, is to discuss the concept of civil liberties in Israel as compared to the United States. And what I mean is, when we all watch these TV shows where the police arrest someone and they read them their rights, the Miranda rights. And we understand, those who grew up in the United States in this culture, that there are certain rights to a lawyer, certain rights to be charged with what you're being arrested for, and other rights of how the prosecution can collect evidence. And I'd like to get into some of these issues here, and so people can understand what the differences are here and how also they affect certain events that are going on today. And I want to start with a story. This story occurred a few years ago. The protagonist in the story is now in the Mechina. So I guess he's around 19. This happened around 4 years ago when he was in high school, maybe less than that. And a fight broke out, kind of like a play fight, or maybe it was a little bit more serious, and the kids were joking around, and one of the boys in our friend's son's class broke his leg, and the mother of that boy pressed charges against our friend's son, and the police arrested him. They wouldn't let his mother be present while they interrogated him. They wouldn't let a social worker be present. They certainly wouldn't let a lawyer be present. And when I looked into it, trying to help the family, I understood that that's just the way things are done here in Israel. And that, kind of led me into trying to understand that, Israel's a Western liberal country. How is it possible that people, especially minors, don't have the same rights that we understand that are given to people in the United States? So let's just start with the right to an attorney. Is there a right to an attorney here in Israel?
Yes, there's a right to an attorney. There are so-called Miranda rights, where you have a right to be warned. That's what's called a caution in Israel. Okay. Right? Before you're questioned, you have to be cautioned.
Caution means what?
That you read your rights.
Oh, okay.
Right? That you're warned that anything you say can be used against you, etc. You have to be informed of your right to an attorney. That said, all these rights on paper are different than they are in the United States in two important ways. So one of them is that in the U.S., there's something called the exclusionary rule, which says that illegally obtained evidence cannot be used in court. And it turns out that has a very large effect on the behavior of police and law enforcement, because if they want to collect evidence that will be usable in court afterwards, they have to play nicely, play by the rules. Now, that doesn't mean they always do, and it may be that they're doing things not necessarily for purposes of gathering evidence, but that exercises some degree of control. In Israel, there is no exclusionary rule. Illegally obtained evidence is admissible like anything else. The judge can decide what to do with it afterwards. The judge can decide whether to give it less weight, to give it no weight, which means that there's no real incentive to worry about it. If the evidence was illegally obtained, it may turn out nonetheless to be the thing that brings about the conviction. So that's one important difference. The other important difference is that the case law in Israel is much thinner. And it's much thinner because the population here is much smaller. The number of cases that come up is much smaller because there's no exclusionary rule, and basically everything is up to the judge's discretion. And judges here don't like making rules; they like preserving for themselves discretion. The rules are fairly thin, right? So you have a right to an attorney, but what happens if it's violated? I don't know. Right?
So basically, it's the discretion of the judge is whether. What would happen is then the defense would bring up these objections to admission of evidence because they were obtained illegally, and then the judge would have discretion to say whether the court wants to nonetheless accept this evidence.
Right. And how much to consider it, what weight to attach to the evidence. So it means functionally it all gets in front of the court. Now, there are other differences that play a role along the way. There's no jury system here, right? And so ultimately, it doesn't really make that much of a difference if there were an exclusionary rule. The judge would still be evaluating the evidence to decide whether to exclude it.
Right. So in the United States, the judge would then instruct the jury to ignore certain evidence that was illegally presented.
More likely, the judge would never allow it into the courtroom to begin with. Mm-hmm. If there's a problem in a criminal case in the United States, well, let me go even before that. In case management in the United States, before a criminal trial, the judge has to get some idea of what kinds of evidence you're going to bring. Who are your witnesses? What are the evidence? And if something is problematic, the judge will likely make a ruling before the case that it'll never get in front of the jury to begin with. Mm-hmm. So it's possible in the United States that the jury will hear illegal evidence, but it's more likely it'll never get there. In Israel, even if you had an exclusionary rule, the judge would be hearing it in order to make a ruling on it. So the judge is going to hear everything, and the judge will do more or less what he or she wants to do without any oversight.
Does the prosecution have to give the defense its evidence, what it plans to present before the trial, so that the defense can then object to certain evidence that is proposed to be presented?
Yes. In Israel, yes, it has to be revealed. That said, if they hide things, right, it's not clear that the judge is going to exclude it afterwards, right? Mm-hmm. The judge may admit it. The judge may admit it with lesser weight. And so you have these rules, but they're not necessarily followed. Now, that we should understand, that's not a difference in kind between Israel and the United States. It's a difference of degree, because all these legal rules are paper rules. They're not the reality, right? The reality is that what protects the rights of the accused in Israel and in the United States is the law enforcement and legal culture. It's not the rules on paper, right? There are rules on paper that are ignored. There are rules on paper that are followed. There are practices that are followed, even though they're nowhere to be found in the rules. And in Israel, there's less of a culture of protecting the rights of the accused. And there's a lot more willingness to apply those rules that protect in a jaundiced, biased political way. Mm-hmm. Now, it's interesting because if you go out, let's say if you go to Europe and the United States, to outside of the Jewish community, the general criticism that you'll hear about lack of protection for the rights of the accused is an imagined bias of the Israeli legal culture against Arab defendants and against those accused of terrorism. And I actually think there it's the strongest built-in protections, because they're the culture that's developed among prosecutors and judges is much more strongly protective of the rights of, let's say, security defendants, Arab security defendants, than it is for almost anyone else. And other kinds of defendants there's much less awareness, desire within the the legal culture to protect them.
And how do you explain the difference in this culture? I mean, the United States has, violent criminals. They may not be as much. First of all, there has been terrorism in the past 20 years in the United States, and certainly in recent years. But certainly violent criminals. Why would there be a culture in Israel that is more protective of accused terrorists?
I think it's primarily a matter of the kinds of criticisms to which law enforcement feels vulnerable in Israel.
Criticism, you mean from the public or from the press?
From anyone. So let's say in the United States, there's two large groups that you have to worry about criticism from. So what is the peer group? Fellow attorneys, fellow judges, right? The people within the system, and those people in the system will criticize you if you behave in certain ways. And it goes beyond just your judges. It goes to attorneys in other jurisdictions, judges in other jurisdictions, even media reporting in elsewhere. But that's one group. The other group in the United States is more sensitive to public opinion. It's political in some way or another, right? An elected DA. Being subject to the authority of the president, but somehow or another being either the system is run by an elected official or is responsible to an elected official, and so if it gets too far out of whack in one direction, you'll see the public rebelling. And you're seeing for example, in the United States right now, there are a lot of political controversies about law enforcement, about policy for bail, for example. Right?
How high the bail should be for certain defendants?
In a number of jurisdictions in the United States, bail has just been eliminated. For most kinds of crimes, you don't release people on bail; you just release them because they're not held on bail anymore.
Because there's no flight risk, or because they're
because it's a matter of policy not to hold these people, right? And the public, let's say, a lot of places doesn't accept this policy. This is something that came up recently. The San Francisco is one of the jurisdictions that disfavors holding criminals pending bail. New York City is the same, but because San Francisco is, and because one of the candidates was from San Francisco, that it's something that was raised in the presidential election. Now in Israel, none of law enforcement is responsible in any way to the public. Right? They're more or less autonomous, and so what's of interest to them is peer judgments. And the peer judgments they're interested in are their fellow lawyers and judges.
People in the legal community.
People within the legal community. And people within their community of self-perceived peers elsewhere in the world.
The international legal community.
Whatever group they share cocktails with in New York and Paris and London. That group is very, very keen to hear that the rights of Palestinians are being protected. And the rest of the stuff just doesn't interest them.
Right. So what you're pointing out is that in the United States, at least, there's a connection to the people. Either the prosecution or even the judges are elected directly by the people. Like, state judges are elected by the people. Prosecutors and state prosecutors are elected by the people, or at least in the federal system, the president will appoint the president in power, who was elected by the people, would then appoint federal judges and federal prosecutors. as opposed to Israel, where the people don't really have any say in who the prosecutor is and who the judges are.
Well, ultimately, I would say the point is bigger. What disciplines behavior is accountability. You have to give an account to somebody. Now, political accountability is not the best kind of accountability in the world, right? What the public reacts to and how the public reacts and how it ends up translating into votes, it's not a straight line, right? And so you can see there are all kinds of problems with political accountability in law enforcement in the United States. That said, in Israel, there's basically no accountability. The law enforcement community is on its own. It does whatever it wants. Senior figures in law enforcement often assure us that they've got the public's best interest in mind, and they're acting in good faith, and they're doing their very best. And they shouldn't be criticized because that really weakens the system. And I'm sure they're very sincere in believing that, but ultimately, without having to give an account, without being responsible, without having accountability in some fashion, there are misdeeds, there are problems, and it's desperately needed here, some system of accountability. And without it, what you have is rights on paper that don't get translated into reality.
Well, the other, I guess, check, even under a system where prosecutors and judges are not elected by the people, would be the press. The press would criticize a prosecutor, would criticize judges. Is there a role here in Israel that's played by the press in terms of keeping these officials and judges in check?
Well, not very much. Let me tell you why. I mean, what the media is not uniform, right? There's this. You can see this in the United States as well. That the media is quite partisan. You can identify the partisan identity of almost any media outlet that you're interested in. In the United States, traditionally, the mainstream media was more associated with the left and the right. In recent years in the U.S., you've had more of a development of right-wing media that's happening to a much lesser degree and much more slowly in Israel, partly because of the regulation about media in Israel. But you have right-wing media outlets in Israel, so you will have partisan coverage. You know that you look at certain stations, you'll get a left-wing perspective on this, and you look at others, you'll get a right-wing one. But because of the makeup of the law enforcement system in Israel, and again, they're not appointed politically, they're not appointed by the public, they're largely self-appointed, and that means that political biases are self-reinforcing, and so the political ideology of law enforcement is almost entirely uniform. And that means that one of the interesting things about media coverage is that they're only interested in media coverage from people they consider to be their peers. They're worried about their peer reputation. And so given the political orientation of judges, for example, if they're criticized on Channel 12, that bothers them. If they're criticized in Haaretz, that bothers them. They're criticized in Channel 14. Not only does it not bother them, they view it as, chutzpah for Channel 14 to speak in that disgraceful manner towards them. Mm-hmm. It's proof that they're on the right track and a reason to consider punishing Channel 14. So public media coverage has much less ability to affect or to cause them to be accountable in Israel than it does in the United States, and also it works only in one direction. It works only in one political direction, the political direction that matches the dominant political ideology of law enforcement.
So let's go back to this right that we talked about, a right to a lawyer, and the story that I started with. Why wasn't our friend's son, who's a minor, allowed to? Usually, you would say, if I was representing this person, I would say, you don't talk to the police without a lawyer. Could you do that here in Israel? If the kid got in front of the police and said, I'm not talking to you until you allow my lawyer, or at least my parent, to be present, what would happen?
So the police might or might not listen. I would suspect they probably wouldn't. But let's imagine it's not a child, okay? Any adult, you can't. Somebody says I won't speak to you until I get my lawyer here. The police will start warning that person, that accused, about his failure to cooperate is going to lead to all kinds of adverse consequences, and they'll give him bad conditions while they're holding him until the lawyer arrives, and then they'll play other games. It's always possible to play games with it like this within the framework of theoretically guaranteeing your right to a lawyer. So is it possible that they would hold off questioning until there was a lawyer? Yeah, but it's also possible that in the meantime they would alert child services they want to take this child away from his or her parents, right? And that doesn't mean that that's what would end up happening. But if you're a concerned parent, you don't want to end up in a proceeding like that, right, where you have to defend your ability to raise your children.
Right. But so what you're pointing out is that in the United States, what really keeps the prosecution in check is the idea that any evidence gathered using these onerous tactics will then never be admissible in court, and you won't be able to use it to prosecute in any event. So it doesn't make sense for them to use tactics like that. Where in Israel, even if they obtain this evidence illegally, it would still be admissible, and they could still get the prosecution or the conviction that they wanted to get.
It's not that stark because it's not that great in the United States either. I was just reading a story, and I don't know anything beyond what I read in the paper, but there's this case, I think it's in Georgia, where it's in a rural area, and a 10 or 11-year-old boy decided on his own to walk to town. Okay? And it's because it's a rural area, a lot of kids do that. In this particular case, he didn't have permission from his parents. He was disobeying. And the police picked him up on the road. And what they decided to do was to arrest the mother for the fact that the child was unsupervised on the road, and charge her with various crimes of neglect. And the threat was, if she doesn't play along, then they're going to report this to child services, have the child taken away, and let her fight to get her child back. Now, it's shocking, but it's part of the way any legal system works. The rules don't operate on their own. They don't accomplish the outcomes on their own. There are people who act badly within a framework of rules. There are people who act well, and there are cases when law enforcement, which is possessed of gigantic powers, misbehaves. It happens in the United States. It happens in Israel. It happens everywhere in the world. Now, the point of the systems of rules, the point of all these protections, is not to get to zero such cases. It's to greatly reduce the number of such cases, right? So it's not. I wouldn't hold on to the idea that if we had an exclusionary rule in Israel, then everything would be good, because I'm not sure that it would be at all. I think that there's serious problems in the legal culture. And also, as I said, using an exclusionary rule in Israel would be difficult to enforce because it would be the judges themselves ruling on whether they're allowed to see the evidence. So they would look at the evidence and then tell themselves to disregard it. So I think that it would be a good idea to have an exclusionary rule in Israel, but I'm just wouldn't put too much on that. The problems in the Israeli legal culture run much deeper than that.
Right. But just on that point, in the United States, if a prosecution violated a right and that led to evidence that led to the accused conviction, and the judges made a mistake in allowing the evidence, you would be able to appeal that conviction to the higher court and show that the judges allowed illegal evidence into the body of evidence to convict the accused. Is there a similar appeal process in Israel, even though the judges would be telling themselves, you would appeal to say the judges should not have considered A, B, and C in the facts that led to the guilty conviction?
Yeah, so it does happen in Israel where there are appeals and collateral processes that go on for years, for decades. Right? There was a quite famous case. I'm trying to remember how long ago this was. About a year and a half, 2 years ago, Zadorov, who was convicted of murder, and more evidence came to light. And after, I think, about 20 years in jail, he was released. Right. Now, it can happen. It's not a technical objection that the evidence was illegal, therefore must have been excluded, therefore the accused must be released. It's more of a question of this evidence, if it were illegally obtained, should have been treated as less reliable, and therefore the appeals court will let him out. What you have in the Israeli system is you have a tendency for the facts to be reevaluated at every step of the legal process in a way that would never happen in the United States. In Israel, the rule is that the trial court is supposed to make its decisions on the facts, and then thereafter you're supposed to be dealing with legal questions. But judges feel free to disregard that as convenient in Israel. And so essentially, higher courts can, if they want to interfere, reevaluate the facts from scratch, and they do. So it's not impossible for such a thing to happen in Israel where there's illegal evidence, or evidence was obtained without the presence of a lawyer, or the evidence was obtained by using forbidden physical force or extortion. It's possible to eventually get that to throw out a conviction. It's less likely than in the United States, and it's not certain it's going to happen at all.
Right, and is that because the judges evaluating the case on appeal are likely to be from the same group of peers as the judges that originally convicted the accused? So you're not getting, in America, you would have a mix of judges. Some of them were appointed by a Democratic administration, some of them appointed by a Republican conservative administration. And that the idea is that balances out so that in any judges reviewing would be made up of a mix of people with different political outlooks that might come to a different conclusion, hopefully based on the law, not based on their worldview, to either affirm or overturn a conviction.
Yeah, I think that's exactly what I'm talking about when I talk about the legal culture. Mm-hmm. The culture is that where the prosecution messes up, there's a built-in tendency of the judges to try to protect the prosecution. And this is because they get publicly criticized, they feel they're in danger, their whole system is going to come crashing down. And so even if it's a completely garbage case with no evidence or little evidence, and a legal theory that's preposterous, the judges are going to not let the prosecution down the higher the profile of the case. If you look, for example, the prosecution of the prime minister, I think that this is, if it were a lower profile defendant, I think that judges would have more of a tendency to to laugh this thing out of court. But in this particular case, the prosecution's gone so far out on a limb that it'll be very hard for the judges to just dismiss it.
Right. So that's an example. Take the prime minister, the case against the prime minister, where even at times you felt like the judges were criticizing that the prosecution for going too far, and I guess that is something that should give us a little bit more comfort that even within the system, that if you step over a certain line, you can be criticized by your own peers, even though you both come from the same group of people and the same group of peers and the same political outlook.
It gives me no comfort at all because
tell me why.
So here, let's take an example, right? The prosecution finished its submission of the evidence on one of the legal claims in the Netanyahu case, and the judge said, I think it's really difficult in a bleak fashion. They said, find it difficult to believe that you can convict on the evidence that's there so far. And the prosecution responded, don't worry, the defense is going to present its case, and then that'll be enough to convict. Now, that's preposterous, right? If in I think a well-functioning legal system, if the prosecution for a crime cannot present enough evidence to convict, then that's reason to dismiss the charges right there.
Is there no burden of proof in Israel?
Of course there is. Of course there is. Right? They clearly have not met their burden of proof. But they felt the prosecution felt comfortable saying that because basically they're calling the judge's bluff. Mm-hmm. Right? The judges are not going to summarily dismiss this. No chance. Right? The prosecution has gone out so far, and this has been a central political issue for so long that there is no way that judges are going to dismiss this as a meritless case. They can't. Right?
So one of the things that we saw in the Netanyahu case, which was disturbing, which was the way that the prosecution gathered evidence by detaining people who they thought could become government witnesses, threatening those people either with a prosecution against them or one of their family members, and hoping to get that suspect to turn state's evidence and become a witness for the prosecution. Would that kind of thing be able to happen in America? What kinds of safeguards would we need to protect that from happening here in Israel? And first, correct me if I'm wrong. Am I giving a distorted picture of what happened there with some of the witnesses? We heard about witnesses being threatened with a prosecution against a family member, and that either the witness the suspect had to become a witness against Netanyahu, or the prosecution was going to prosecute that person's family member.
Right. So no, I think that you're describing this accurately. Mm-hmm. I think it's not unique to the Netanyahu case, and I think that unfortunately this happens a lot. And we're now watching every night on the TV screens another such case where it's fairly clear that people are being held and threatened with various kinds of actions. They'll be charged with serious crimes, or they won't see their spouses again, or other drastic measures unless they agree to become a state witness. It happens a lot. And there are not a lot of effective tools in Israel to prevent it. It's not because they don't exist in theory. It's because judges won't use them. Right? The reason it's less likely in the United States is that if you engaged in that kind of misbehavior, it's not just that the judges would exclude the testimony of that witness. The judges would not cooperate in the continuing detention, right? So
how do they have to cooperate? Detention, you're saying that what judge has to approve a detention of a suspect?
Right. Somebody who's brought in suspected of a crime has to appear before a judge within 48 hours, and the judge has to approve holding him. It's also, but the other things, they seize his phones. If they didn't have a warrant to seize the phones, then it's an illegal seizure, right? What happens in Israel if you do that? So the judge may tell you off and then allow you to use the evidence you illegally obtained, right? And that's happened in a number of high-profile cases in recent years where there's illegally obtained evidence from telephones that were, right, that is, the phones were illegally seized or they were illegally broken into. And then the judges, after scolding the prosecution, allowed the evidence in anyway. And not only that direct evidence, but the what they call in the U.S. the fruit of the poison tree, the additional evidence that was obtained only because of the illegal evidence.
Oh, so you mean they'll confiscate a phone for one purpose and then use it for another, and use what they've obtained for another purpose?
No, they will seize it illegally. Period. Uh-huh. Okay, so there was a case. This is a satellite litigation over the Netanyahu case, right? The two communications advisors of Netanyahu were arrested allegedly for witness intimidation, and the police, when they did that, seized their phones, and they had no warrant. Right? They had no right to seize the phones. They had no right to break into them and use the information. And after the fact, they went to the court and asked for permission to break into phones. The court said no, it was unlawful, right? And the police continued their operations of getting into the phone, extracting the information, and then they gave eventually back the phones to the defendants in violation of the court order, and the prosecution was and the police were scolded by the court, but ultimately. The police were able to use the information they'd obtained not only directly but indirectly. We found that through this illegal search, we found that the communications advisor was in contact with John Smith. So let's now surveil John Smith to see what additional information we can get. Now, in the U.S., that's a spin-off of the exclusionary rule. It's the fruit of the poison tree rule. In the U.S., not only is illegally obtained evidence excluded, but all the evidence that you get as a result of using that illegal evidence is excluded. Right? The exclusionary rule goes through several generations, several permutations. It excludes a lot of stuff. In Israel, you don't have the exclusionary rule, so you certainly don't have the exclusion of fruit of the poison tree, and so that in itself is a great asset for the police and prosecutors. And it's not because the rules say it's okay to use this stuff; it's because even if the courts say you can't use it, they'll let you get away with it, right? Even if the courts, as in this case, scold the police, say to the police, you broke the rules, you shouldn't have done that, give back the telephones, they won't stop them from extracting the information and using the information.
So what is the deterrence? Is a police officer or a prosecutor that obtains evidence illegally, is that person subject to losing his job or to being sanctioned within the police or within the Shabak or whoever acted illegally in getting evidence? What's the deterrent?
Of course he can, but if his defendant is not of the kind for which the legal community feels vulnerable in cocktail parties in Paris, then it's not going to interest anyone. Mm-hmm. So it happens all the time, and there are no consequences.
Now, let's just take this to, I want to discuss another case because I wanted to bring up the idea of an admission to a crime as being evidence or sometimes sole evidence against an accused. In the Duma case, you remember the circumstances of the Duma case.
Remind me.
Right. So in the Duma case, the accused, or I think one of the only accused that was an adult, Amiram Luliel, I think his name was convicted based only on an admission, which it was claimed
his lawyers claimed was obtained through duress amounting to torture.
Right. And there was no other evidence to that we would call, what would the term for that in the United States would be not mitigating evidence,
corroborating.
but corroborating evidence. Is that something that kind of conviction, or using an admission and only an admission, is that something that takes place in other Western countries and other liberal free countries?
Well, on paper in Israel, there's a rule that an admission alone is not sufficient for a conviction, and that you need an additional something. That said, I would say, like such rules everywhere in the world, they're meaningless on their own. And so Israel's rules on paper about admissions, I don't think are very different than you'll find.
So what happened in that
places.
case? In that case, the lawyers claimed that the admission was obtained through torture, and what happened was the judges agreed with that and said, we will throw out the admission that was obtained through torture, but then after the fact, the suspect admitted it again while he was no longer under torture, and that's the admission that we're going to accept.
Right.
So is that an example of where the judges will kind of use if they want a certain outcome, will either manipulate or choose to ignore certain aspects of the law and accept other aspects of it?
I think that judges in Israel in general are able to exercise a much greater leeway, right? They're able to exercise much more discretion than they are in other law-abiding countries. That is, the rule of law in Israel is extremely weak. And the reason is that the judges themselves, they perceive of themselves as protecting the rule of law, but they're undermining it. And it's because their perception of the law is personal rather than rule-based. Right? Generally, when we say the rule of law, what we mean is the primacy of the rules over discretion. What Israeli judges and prosecutors and police, et cetera, what the legal community in Israel views as the rule of law, is the primacy of the law community's discretion rather than rules. There are ways of massaging every decision so it sounds okay in Israel, but it's primarily because the rules themselves are very squishy and soft, and right? And it's designed to be that way. It's designed to be that way so that the judges can do what they want, exercise their discretion. Now, from their point of view in Israel, this is achieving justice, because justice is judges using their best sense of what's right. The rest of the world, what justice consists of in a rule of law society, is applying the rules fairly to all. But that's not the way it's understood here.
Mm-hmm. So one of the other methods that were used in that case was the basically what the Shabak did, or what they were accused of doing, is detaining certain people in the community in Yehuda v'Shomron, friends of the accused, and holding them under questioning them and getting evidence from those people, which they were getting statements from those people, which they then use against the accused, and that kind of brings me this. Also, we're hearing about this now in the case of the leaked documents in the Prime Minister's office, where suspects are detained under what's called administrative detention, and then the questioning and the information that's gathered under that detention is then used against an accused. Tell me about administrative detention. Am I describing it in correctly? Can you detain someone under this rubric of administrative detention without giving them a right to a lawyer or without charging them with any kind of offense? How does administrative detention work in Israel?
So administrative detention in Israel requires an authorized official to issue a detention order, and that has to be brought before a judge. The person is entitled to a hearing before the judge, and the judge has to approve it or not approve it and set a time on it. And administrative detention orders can never be for longer than 6 months, and then you have to go again to a judge. It's not a process without review, and there's a reason for it. There's an important reason for it, and it's the reason that you see in other law-abiding societies, that you have special tools for fighting, more or less for fighting terrorists and organized crime. And it's because you have an entire subculture there that is designed to cause a vast amount of human misery and to elude justice. Right? It's important for the society to be able to protect itself against those who are abusing the loopholes in the protections of the accused, potentially to commit violence, to be able to stop them. So that said, it's possible to exploit the loopholes. It's possible to exploit administrative detention, and so if you look at, is administrative detention properly applied in cases of accused violent criminals in the Arab community and the Jewish community, is it done properly? And so there are claims, and they don't seem to me entirely exaggerated, that the sensitivity of the judges is greater for those defendants that look to them more like the ones they'll get criticized about in their peer group, and they're less worried if it's a different kind. But that's for the violence cases. So like you take Duma, and you're talking about an act of domestic terrorism. It's Jewish terrorism rather than Arab terrorism, but it's an act of terrorism. Right? When you talk about the current leaked documents case, now we've gone to an entirely different world. Right? There's no accusation here that any of the people that are being held in long-term detention, and it's not administrative detention, they're suspects being held pending a decision on charging them, and ultimately perhaps until a decision of the court.
How long? I mean, what are the rules in terms of what if you wouldn't call it administrative detention? What would you call it? Suspect detention?
Yeah, as a detention pending trial.
Okay, and how long can that go on for?
That can go on until a ruling in the trial.
And does the judge have to approve that?
Yes, the judges, again, 48 hours, and you have to be before a judge. And then the judge says, you can be held for another 2 hours. You can be held for another 3 days. You can be held for another week. Right? It's after they're charged, you can go again and ask the judge to have the suspect held until trial, or until the completion of the trial. Right? You can get an order for 48 hours and then come back to the judge and ask for extensions. And that's what's happening right now, is that the suspects...
You're talking about Feldstein? Eli Feldstein?
Right. And there's another several suspects whose names have not been released. Mm-hmm. Right. And they've gone past the initial orders, and the prosecution has gone back several times to extend the orders to detain them. And there's been a slight amount of pushback from the judges, where some of them were ordered released to house detentions, And some of them, they gave them short deadlines to come back and ask for the next extension. But all of this, let's understand, this is an entirely different kind of matter. What the basic accusation against these defendants, to the degree it's come out so far, is that the accused mishandled classified information with the intent of exposing it to the prime minister and the prime minister's circle, and also to release it to the media, to, according to the accusation, help the prime minister persuade the public. Now, that to me is the core of it, no less than the way that they've been detained. So let's take a different case. Okay? Let's imagine that one of the soldiers who had seen information before October 7th talking about Hamas's plans for attack, and who knew that every time she raised it to her commander, was told, don't worry about it, it'll be okay, and that it's not going up the chain, right? That had never been sent to the defense minister, that had never been sent to the prime minister. Let's say that she decided to take the law into her own hands, and she passed it along to the prime minister. Or let's say even that she didn't have any connections with the prime minister. She did have them, but exercised poor judgment, and instead of taking it to the prime minister, took it to a reporter. Right? Now, how do we look at a case like that today? I think that a large segment of the public would want to give her a medal. Right? A large segment of the public considers it an outrage that this information wasn't passed up the chain, an outrage that cost thousands of lives to this point. And they would want that information to go up no matter what the price. I think that realistically, if such a thing happened, you'd see disciplinary proceedings against the soldier if she passed it along to the media, maybe. I mean, this sort of thing does happen all the time. If she'd passed it along to the prime minister, I should think there should be no consequences at all. The real scandal is that it wasn't passed up the chain. Now, why is this different? Right? In this case, the alleged information was information about Hamas's plans for the hostages, including alleged plans to smuggle them over the line into Egypt. And that information had not gotten to the prime minister, at least according to the way the accused understood it, and they wanted it to get out, and within a context of floods of leaks. So why are they, instead of facing a disciplinary proceeding, why are they being held as if they're dangerous, violent criminals for weeks in security conditions that are those that terrorists get, as if they're dangerous and violent criminals? And the answer is very clearly because of the politics of this, right? That if what they were trying to pass along was something that would embarrass the prime minister, it would never even get to a disciplinary proceeding, because embarrassing the prime minister is something that suits the needs these days of the prosecution. But if it helps the prime minister, then that does not suit the needs of the prosecution. Then you have to throw the book at them. Now, that to me is the most salient feature of the documents case.
So the people that have been detained, are there any restrictions on limits on the conditions that they're held in? Can physical violence be used against someone who's being detained? Can they be deprived of food and drink? Can they be deprived of sleep? Can they be put in uncomfortable situations that will, kind of lead lead them to cooperate more with what the prosecution wants of them? What are the restrictions?
So if you remember in elementary school when you would ask, can I go to the bathroom? And the teacher would say, that's not what you mean. What you mean to ask is, may I go to the bathroom?
Okay.
So can they have all these things done to them? I think the better question is, may they? They may not. It is forbidden according to law, right? They have to be fed. They have to be held in humane conditions. They have to be allowed to see a lawyer. Physical violence may not be used against them, etc. These things may not be done, but they are done. And so, if they are done, what is the consequence? There is no consequence.
Aren't you then ultimately going back to this exclusion issue? That if these things are done in the United States, that it will be exposed and the evidence will be thrown into the garbage because they won't be able to use. And isn't that
that's part, but not all of the picture. Okay, let's imagine that in Israel we had an exclusionary rule, so all of the information they were able to extract from these defendants to date would not be usable. Okay, and let's imagine that because of that. They would ultimately not be charged. Would that deter the prosecution from doing this? I don't think so. And you look at here the reports yesterday were that two of the accused have already attempted or are considering or tried in various ways to commit suicide. Right? They've already had imposed upon them a much greater punishment than going to trial, right? So if you want to send a message, don't you dare help the prime minister, we'll throw the book at you. That message has been very well sent, and it makes no difference what happens from here on. So the exclusionary rule, even if you imposed an exclusionary rule starting now in Israel, that would not sufficiently deter behavior like this. So
what you're really getting at is that the primary issue here is the identity, the actual how people are appointed, how judges are appointed, how prosecutors are appointed. If there's no deterrent, if they can continue doing this, and in even the evidence that's illegally obtained or the methods that are illegally used have no consequences, then doesn't this all go to the discretion of the people that you're actually trusting to uphold these laws?
Yeah, you have a system with almost no accountability, and if you have, as the cliche goes, if you have absolute power, you are absolutely corrupted, and a prosecution, police, a judicial community that answers to no one ultimately will do whatever it wants, and some of the time that won't be good.
So, but we hear when this issue is raised by the right, many times we'll hear, well, what do you want? Itamar Ben-Gvir is the minister who's in charge of the police. How can you blame the police for what they're answering to Itamar Ben-Gvir? And he certainly doesn't want them using these methods to attack the elected government in power now. So how does that work?
I think that if it were true that the Minister of Internal Security bore ultimate responsibility, that is, he was in charge, he could give them orders and they would do what he said. If he were in charge of this operation, then he would be the address for our complaints. I think that's right. But we know that he is not the address, right? He hasn't got that authority. He can give any orders he wants to regarding the detention of these individuals, and nothing will happen.
But there's something that I don't understand, and certain people that I speak to don't understand. At the end of the day, the prosecutor can be fired by the prime minister. The attorney general can be fired by the prime minister. Judges can't be fired. But certainly a police commissioner can be fired by the Minister of Internal Defense, Internal Security. What's the response? Why isn't that happening?
Well, it's not clear that they can be. You're saying that they may be, right? That is,
okay.
on paper, the government can dismiss the attorney general. Now, what will happen next? What will happen next is that she will go to court, and the court will back her up. They will say that the decision to fire her was unreasonable, or didn't consider all the relevant factors, and so her dismissal is reversed. She's still in office, and now you have a problem. You have somebody who is claiming to be the attorney general, notwithstanding having been fired. Okay, and who will the police follow? Who will the military follow? Who will the attorneys follow? And that's a recipe for civil war, right? So you have a situation where it's not easy to fire these people for misbehavior. No matter how bad the misbehavior is, apparently they're going to be backed up by the court. It's not, it's easy to get into a situation where people start shooting, and it's not easy to reverse it afterwards.
But why does it seem like certain elements of society are more concerned with that danger and others are not? In other words, what I'm trying to say is that it seems that the right-wing community is more concerned with the breakdown in society or a constitutional crisis that would be the outcome of this than the left is concerned about it.
Yeah, I think it's because this is a weapon. Well, there are two reasons. Okay, so one of them is that the right now is ascendant in elected offices, but is definitely not ascendant in the bureaucracy. Right? So for the right wing, primacy for elected offices is good policy-wise, whereas for the left, the elected offices are where they're going to lose. They want primacy for the bureaucracy. So anytime they see the elected offices doing something, it's the left that wants to make the threat, not the right. And the threat that they have will bring everything tumbling down. They're the ones who want to make the threats. Now, it's not like it's impossible to imagine a situation where the right wing might threaten this, right? It's like you have to stop what you're doing, or we'll bring everything down. And you actually have had elements in the right that have tried to make threats like that in the past. So it's not intrinsically right-left. It's more a matter of the circumstance. Mm-hmm. But there's another issue here, which is that because the bureaucracy is oriented politically towards the left, and therefore the senior generals and the senior police officials and senior prosecutors are all oriented towards the left. The ability to fight in this way is much greater for the left than it is for the right. And you can see, for example, in the battles before October 7th over the judicial reform issue, it was quite effective for the left to organize refusal to serve in the army, right? Refusal to carry out civil functions, illegally blocking the airport, for example. Closing down all the universities illegally, right? Shutting down roads illegally. Right? Now, if you're of long tooth enough, like the two of us, you'll remember that Moshe Feiglin was prosecuted and convicted for sedition, for organizing protests that blocked roads during the Oslo years. Right? He organized a protest that shut down Kvish Gea, and That was sedition. Okay? And he was ultimately convicted. Now, what do you think would happen if I tried to bring a suit? Like if I went and filed a complaint and asked the prosecution to please prosecute the leaders of the Kaplan group for blocking roads, for sedition. Right? It would never happen. It would never happen because the judges aren't that way, and the police aren't that way. This is the ability to wield weapons of this kind. Like to fight dirty, to put your opponents in jail, right? To order troops to use force for this and not for that, right? It's not symmetric. One side is able to do this, the other side is not. Now, it's not intrinsic in the system. It's simply the result of the fact that it's one political grouping that's in office rather than the other. But it's going to stay that way indefinitely because the legal community is mostly self-appointing, and it keeps appointing itself in the same political orientation. So until there's some very, very large external shock, it's going to be in this orientation forever.
So you mentioned the proposed judicial reform. Could the proposed judicial reform have taken care of a lot of these issues that we've talked about in the past hour or so, in terms of prosecution discretion used in the wrong way, in terms of judges using their discretion in the wrong way to ignore laws of evidence, in terms of administrative detention, in terms of when the law enforcement will decide to arrest someone for blocking a road and when they won't. How was the proposed judicial reform able to deal with these issues?
So the proposed judicial reform was, in one sense, very narrow, and you could say, what would it do? All it would really do is introduce certain kinds of accountability at the very top of the pyramid, at the level of the Supreme Court, right? It would affect certain kinds of doctrines that the court has used to give itself power and to give the Attorney General power. Unreviewable power, unaccountable power, but it would that's primarily what it would do. And then by opening up that space to politics, right, by allowing these discussions to take place, you might get a law that would change the rights of the accused, or would be able to, you'd see appointments of different people that would be more likely to apply the law in an unprejudiced or unpolitical, unpolitically biased way. But it's not that a reform would do it in and of itself. It's that it would be releasing one of the main blocks on getting reform done in prosecution, right? That is, as long as you have the judiciary backing up prosecutorial misconduct, it's very hard to fight. Right. Let's say you actually got the Attorney General to resign. Right. Would that change the entire environment? No. The next Attorney General would be appointed by the same process, would likely be the same as the prior one. Right. That's what happened in this appointment.
So what's the key?
So I think that you have to, in some way, pull that cork from the bottle. Right. It's absolutely necessary to change the system in which the judges authorize and support and create all this kinds of misconduct and prevent political accountability for anyone, right? Now, you get rid of that cork, right? You pull it out of the bottle, then we can start working on the rest of the items. So to me, it begins with a judicial reform. Now, the particular one that was proposed is a collection of proposals that were made primarily by the Justice Minister and member of Knesset Simcha Rotman. They're not the only possible proposals. There are lots of ways to do this. And frankly, if you asked me, I think some of the things that they were proposing were not far-reaching enough. I think that they have to go farther in order really to pull the
What is the cork
out.
here? Tell us exactly what the cork is that would allow for this change to be made.
It is the power of the Supreme Court. It is the power of the Supreme Court not only over ordinary rulings, it's their power over legislation, it's their power over appointments, including appointments of themselves.
You mean the power of reviewing appointments, reviewing legislation?
No, it is the power of appointments. It's not simply they review. They can order somebody to be appointed. They can order somebody not to be appointed. They can actually more or less force criminal charges against somebody for appointing the wrong person, right? In fact, there was an attempt like this, if you recall, in Netanyahu's first administration, right? What was the name of the gentleman that he appointed to be Attorney General? Do you remember? He was afterwards a member of Knesset. But at any rate, Netanyahu appointed him. And there was this cooked-up scandal that Netanyahu had allegedly done this in discussion with Deri, had come up with the name, and that was criminal. That was breach of trust. You have to bring charges against him. And
so you're not talking about Yaakov Neman, are you?
No. It was I'm not remembering his name at the moment.
Well, they're trying to do the same thing now. They basically, the Supreme Court announced that it's reviewing the reasonableness of continuing Itamar Ben-Gvir as the minister.
Right. So it's not about review, right? It's not about review. What essentially the Attorney General wants to fire Ben-Gvir, right? And the question is going to be, is the court going to go along with that play? And it's not because, the question for the court will be a political one rather than a legal one, because under the doctrines the court has made up, anybody can do anything, right? The Attorney General can do anything she wants. The court can do anything it wants. They can fire Ben-Gvir. It fired Deri already, twice, right? The question is whether they want to go along with it. But ultimately, this means it's not a question of reviewing. The court has the power to appoint anyone it wants. It has the power to fire anyone. It can make budgets and destroy budgets. It can, order the army to carry out this maneuver, stop the army. And so what we're talking about is not about review, because you can't think about this in terms of law. This is not about formal legal powers. It's a question of taking away the absolute unaccountable authority of the Supreme Court and returning it to the kinds of powers that courts have in other democracies in the world.
So if the Knesset enacted legislation restricting that power, who's to say that the court wouldn't just strike down that legislation?
I think
right back where we were.
I think that one of the most dangerous, perhaps the most dangerous decision of the Supreme Court in its history was the decision to declare invalid the reasonableness law. Now, if you'll recall, there was, of all the judicial reform, one minor law passed, which restricted the ability of the Supreme Court, sitting as a high court of justice, to use a doctrine that it invented about 50 years ago, this reasonableness doctrine, to review certain kinds of decisions by elected officials. And it's fairly minor, I think fairly common sense piece of legislation. One can argue about the way it's drafted, but that's neither here nor there. Ultimately, what the court decided was it decided that there's an invisible constitutional provision in the invisible Israeli constitution, right? We haven't adopted a constitution. And so any one of the provisions of this invisible constitution are going to be invisible themselves. The court said there is such a thing, and therefore was striking this down. Okay, now, we can argue about this on legal merits, but I think that the more important way to understand why it's such a dangerous decision is you had this lengthy political fight about how to reform the absolute powers of the court. And the court at the end of it decided, no, we're going to keep our absolute powers. We don't care what laws you pass. You can pass the laws according to the rules, right? A majority of the Knesset in all readings can give it, 61 plus votes. So it's an appropriate, lawful amendment to the basic law in question. You can do all those things and we still won't respect it. We're still going to throw it out. Now, what options has the court left for reform now?
None.
It can't be done by law anymore. Now, more or less, the court has said, if you want to change our powers, you have to use guns. And that's an incredibly dangerous thing to say. Now, at some point, you hope, before we get to such a horrible situation, enough of the court will realize what a mistake they've made and step back from that position. But yes, at the moment, we are in a very dangerous situation, which the court has more or less said, if you try to change our powers by law, we won't go along.
And not only that, but other elements of the bureaucracy will use their powers to strong-arm the government to back down, which is what we saw happen
in the judicial reform.
Right.
Yes, absolutely.
So, so we're talking about a constitutional crisis. We're talking about a crisis between two arms of the government, the judicial branch and the executive and legislative branch, and that are ultimately dancing around this conflict that at some point is going to have to come to a head unless one of the sides back down. Basically, a game of chicken.
We are in a game of chicken. We've been in a constitutional crisis for several years. We are in a game of chicken, and at every point, the elected authorities have withdrawn first. At no point has the court indicated any willingness to back down, and at no point has it backed down.
Now, has this affected the IDF's ability to fight this war that we're involved in now, a war in Gaza and a war in Lebanon? Has this control by the judicial and the inability to, or the refusal to entertain any changes, has this affected our ability to fight these wars?
Well, only indirectly, but certainly there is a problem of the conduct of the Attorney General, of the legal advisors, of the criminal prosecution that has seeped into the conduct of military affairs. And so just a few months ago, there's a very celebrated case where the criminal prosecution in the Army wanted to bring charges against a number of soldiers for allegedly abusing a prisoner in Steteman. Right? And it's unclear that there's anything behind this accusation. The evidence that has leaked out is far from compelling. It seems to me, from the evidence that's leaked out, nothing happened, certainly nothing criminal. But the prosecution nonetheless went forward not only with very loud arrests and attempts to coerce the prisoners into turning on one another, and so that they would, not the prisoners, the accused, the soldiers, into turning on one another so that one would cook up a case against the evidence against the other. The criminal prosecution actually leaked a doctored film to try to make it appear as if the soldiers had abused the prisoner, which not only was a violation of every right that the accused have, but did severe damage to Israel, its ability to carry on combat operations. There you have right now a situation in which you have Israel's fighting the terrorists holding hostages in Gaza, and the terrorists are actually quite undeterred. Right, like, you fight. If you get captured, then you'll end up in a fairly nice, cushy conditions, and eventually you'll be released when the jails get emptied out to pay for the hostages, right? So you've created a situation that the combination of the politics of this and the prosecutorial misconduct have created a situation in which our combat operations in Gaza are severely harmed. Now, is this because of the way judges are appointed to the Supreme Court or because of reasonableness? No, but it's a fact. It's a fact that the prosecutorial misconduct that occurred in this and in other cases will not be addressed by this Supreme Court. This Supreme Court will not make any orders against the prosecutor in the Army or against the Attorney General who's approving this, right? Why won't it? Because of the problems we've been talking about.
Is that the same case? Would you say the same thing about the issue of demonstrators in Gaza coming too close to the security fence and our inability? I mean, you tell me whether the Attorney General or the Supreme Court had anything to do with the IDF's inability to keep people away from the fence in the demonstrations that were occurring before October 7th.
So somewhat, I mean, that's actually an interesting case. In that case, the legal advice the Army was getting was not nearly as bad as it could have been. Right. That is, it was allowing the armed forces to use certain kinds of force. Now, that said, it wasn't absolutely allowing them up to the limit of the law. So there were cases where they're very publicly covered prosecutions of people for shooting, of soldiers for shooting in those situations. Now, I
mean, shooting the Gazans coming too close.
Shooting to the wall. Gazans coming too close, right? Now, we now know, looking back at this, that was the early stage of Hamas's invasion plan, was to test the borders, to use these kinds of so-called demonstrations to probe Israel's defenses, to soften Israel's expectations so it wouldn't do anything when masses actually arrived in order to cross the fence and murder and rape and pillage and take hostages. So we know that now. At the time, interestingly enough, it was fairly well discussed by intelligence officials that they wouldn't say it was part of a plan, but this was the danger. The dangers would be that they would break through. And there was some legal authority that was given by the legal advisors. That is, they were less interfering than they would ordinarily be. Mm-hmm. And it was the senior leadership of the military, I think, that refused to take this seriously, that refused to authorize up to the legal limits, and maybe beyond the legal advice up to the real legal limits, rather than where the legal advisors were placing it. That didn't happen. You didn't have any pushback from the Army. The Army was actually happy to have its hands tied by the legal authorities. So it's not 100% the fault of the legal authorities. That said, they definitely did contribute to an atmosphere in which the military was not using all of its abilities to fight against potential crossings of the fence, and it would behoove us to examine that very seriously now. One of the reasons why it's so problematic that the Attorney General is insisting that any investigation of the events of October 7th has to be led by a judge within a legal framework that basically makes it a judicial process, is that's necessarily going to exclude any serious examination of the role of the judiciary and the legal authorities in creating the problem.
But what would be the Army leadership's interest in restricting itself? If the Army is in charge of security and you're saying the intelligence community understood that this was a serious serious security situation of Gazans coming too close to the wall or testing the wall or coming across the wall or damaging parts of the fence, what would be the Army leadership's interest in ignoring their own powers to deal with this?
I don't think you should look at it as what's the military's interest. The question is, why would senior figures in the military think this? And why would senior figures in the military think this? It's not necessarily an institutional interest, although it might be, right? It's a lot of groupthink and political ideology and internal social politics, right? It's, I think, a story that we know about because, we've unfortunately had to deal with this previously. Why was it that the military was absolutely unprepared, although it knew lots of things and was able to do lots of things? Why was it absolutely unprepared in Yom Kippur in 1973 to deal with the Syrian-Egyptian invasion? And it was a complex set of groupthink factors and social dynamics within the army and politics. And in Israeli jargon, they call it these days the koncepcja, right? The preconceived notion that took hold of the army. And we're in a not very different situation now. What creates koncepcijas like those? It's to a large degree, it's an unaccountable bureaucracy. The lack of accountability is not solely in the legal fraternity. There's a larger lack of accountability within the entire bureaucracy in Israel. Right? There's limited oversight, and people answer more to the peer pressures within whom they define as their peer group.
So in the case of the military, we know that certain senior personnel in the military are also in traveling in circles in the international community, traveling in circles that include U.S. Military officials, high-ranking officials. When they retire, the Israeli military officials are able to get speaking engagements, are able to become fellows or write for a certain think tank or get any other kinds of access. Is there a United States involvement that is kind of shaping the way that our military leaders think in this aspect?
Yes, but I don't think that it's responsible for the koncepcja of October 7th. But most certainly, a lot of the generals conceive of themselves as in charge of, or particularly well-informed and very smart and skilled in conducting international relations. And they want to impose what they perceive as the United States demands or U.S. interests within the system, because they believe ultimately Israel cannot survive without the friendship of the United States and without the support of the United States. And so they think that they've got a better idea than the prime minister or the government or the defense minister or whoever of how to conduct those relations with the United States. And so they're going to impose it. And that's one of the things that happens. It's one of the parts of the politics of the military. But a lot of it is just stubbornness. Mm-hmm. Right? So I'll tell you a story. This was back in the Oslo days. Right? So there's a senior general, I won't say his name, in the army at the time, who was very well known for his belief that we are on the verge of a peace agreement with Syria, because Hafez al-Assad was really, really serious about it. Right? So I was there was a very, very small group, and we were talking to him about this. And why are you so convinced that the Syrians are interested in peace with Israel? So he started talking. My generation, we just followed orders. We did this. We did. We walked in a straight line because they told us to walk in a straight line. And times have changed. Assad is older too. He has to see this as well, right? That's his analytic process. You engage in a little bit of navel gazing, and then you project it onto the other guy. Now, that's not a serious analysis. That's not but he was absolutely sincere about this, and that's what passed for analysis within his circle. In fact, to say otherwise would be to put yourself outside of the group with the bad guys, right? And that's much more of a problem than attempting to suck up to the Americans. I think it's more of these are people who are not engaging in serious analysis on very core issues, right? They're engaging in, social dynamics of small circles. And if there's any particular thing that's more important to them, most important to them, it is protecting the boundaries and of their identity group. Kimberly would call the Husalim, the Ashkenazi, secular, socialist, non-immigrant Israelis, and their control, and to make sure that the other groupings understand that it's not their country to run. Right?
So, okay, and I want to get to this ultimate question, which is, now that we've pointed out a number of problems in the Israeli judicial system, in the way officials are appointed, in the way they can be dismissed. We talked about how judges are appointed, and that the judges, there's a cooperation between the judges and the officials. And then we've also mentioned that this game of chicken that's going on, where we see these things coming to a head, where any kind of legislation that is proposed that would take away from the power of the bureaucracy or from the judiciary will be struck down. And the refusal of the elected government to actually take this to a point and to use its power that it has to further these changes. What are we supposed to do now? What is an ordinary person supposed to do? We live in a democracy. We're being told all the time that what the most important thing is the rule of law and democratic policies and the people. But yet we're seeing that the people don't really have the ability to govern here. And many times that affects our ability to fight wars. It affects the climate of accused rights, of how things are done here in Israel. What can we do now? We can't enact legislation. It'll be struck down. It seems like we're coming towards a crisis, and because one side is willing to pass a certain red line and another side isn't, we're kind of stuck where we are. What, if anything, can be done?
Look, politics is complex. And so the fact that the bad guys won in the previous round of judicial reform doesn't mean that that's the way it's going to end the next time. But it's important to be careful and clever about the way we fight this political battle. It is ultimately a political battle, and the idea is to create situations where you fight about pieces of reform where the judiciary and the prosecution, the legal community will not feel comfortable pulling out doomsday weapons the way they have in the past, where they won't, you won't have ex-judges getting on the radio telling people to take to the streets, and basically encouraging mob violence. What they felt comfortable doing then, they won't necessarily feel comfortable doing after October 7th. Mm-hmm. Depending on the issue, they will feel more and less comfortable. I think that it's possible to win this political fight if we're very clever about it. We just mm-hmm. have to be careful about when and how we raise the issues, and not get into a dynamic in which they can threaten to bring the whole house of cards down when they don't get their way.
Right. So one example, that comes to mind now was the appointment of judges. So there was a whole complex system that was kind of negotiated, whereby the elected government would appoint certain of the judges, the opposition would appoint other judges, the committee would appoint some of the judges, and in that way, the proponents of the judicial reform would feel at least that they were getting in some judges that had a different perspective on things. What about just proposing that the people elect the judges? to me, it seems that the left would have a more of a difficult time objecting to that, whether it's a good situation or not. Whether you could say that, it makes, judges will then be answering too much to the people and not enough to legal concepts or justice. But it is a way that the left would have a harder time, because what the left, the way they argued against the judicial reform in this way was they said that, well, you're consolidating power in Netanyahu's government, and he's using all kinds of elements of society that are radical right, and therefore he's going to solidify power, and he's going to choose the judges that he wants to choose. Just say the people get to elect the judges.
I think that you're giving too much credit to the arguments that they make. They're Here, let's go to a different thing. What's the thing that Israel can do in order to not get accused of war crimes? Right? Can it make different rules of engagement or different rules? The answer is no, of course not. It doesn't make a difference what Israel does. It'll always be accused. Right? The accusations appear because there's a Jewish state called Israel, and there's an international political environment in which there are a lot of actors that have an interest in making accusations against Israel, whether Israel acts imperfectly or perfectly. Mm-hmm. Right? So I think it's a mistake to try to think of the opposition here as related to the content of the proposals. The particular judicial reform proposals that were on the table were numerous, from numerous places, and included, by the way, all kinds of compromise formulas. But they had nothing to do with the opposition to judicial reform. They had nothing to do with it because the opposition to judicial reform was about Netanyahu, or about the groups that were perceived as supporting this, not Ashkenazi secular, et cetera.
Preserving a certain hegemony.
Right, and preserving the hegemony of that social group, the Ashkenazi socialist, non-immigrant, secular, et cetera, group. And they, it didn't make a difference how the proposals changed. So as different ones came around, they were all bad, right? Even if they were almost the exact opposite of the previous one. So I think it's a mistake to think you can get past the kinds of opposition that you had in the last round of judicial reform a year ago by tweaking the content of the proposals. It has nothing to do with that. It has to do with the timing and the political posture of the reforms, and where the court stands otherwise, and where the prosecution is, and where we stand in the war. Those are the things that are going to make it succeed or fail. And what is the particular reform that we ought to propose first or go on? I think it's a premature conversation to have, right? We have to create an environment which is possible to have a political discussion about the reform before we can actually enact it. And so enacting it is obviously going to follow some kind of process about what's the best reform. And why should we foreclose options at this point when we need to have that discussion? And why should we assume that if we foreclose them, then all of a sudden everybody's going to come running, oh, now we'll talk to you? They won't. They're not willing to talk, right? So you have to get past the games of chicken and the doomsdays. And once you get past that, we can figure out the right reform.
Or how do you get past that?
So again, this is a question of raising issues strategically, carefully, and consistently. Mm-hmm.
Okay, there's so much more to talk about. Maybe we'll have to have you on for a supplemental discussion. A lot of issues that I wanted to touch upon. Thank you so much.
Thank you,
Professor Bell, for joining us. And let's hope for good news in the future. And a lot of these problems will hopefully get solved, and Israel will be able to defeat its enemies, and we'll see peace in our time.
Amen, amen.